Hello, everyone, and welcome to this Legal 500 and BKL webinar, Practical Implications for Companies Doing Business in Korea by the Revision of Competition Law. My name is Joe Boswell. I'm head of the Legal 500's GC Powerless series, and I'll be introducing today's session. We're taking a deep dive into what you need to know about new Korean competition legislation today, and we have a fantastic panel ready to tackle today's topic. We have Sang-Hoon Shin, Senior Foreign Attorney at BKL, Ki-won Shin, Senior Foreign Attorney at BKL, Richard Shin, Senior Advisor at BKL, Hyun-A Kim, Partner at BKL, Hugh-Sik Kim, Partner at BKL, Jun-Yun Cho, Partner at BKL, and Nicole Lee of Uber. I will throw over to Ki-won now to begin the session. So please go ahead, Ki-won.
Thank you, Joe, and thank you everyone who joined us this afternoon or morning or wherever you may be joining from. I just want to first of all apologize for the masks, given the number of recent COVID cases in Korea and the relevant regulations. We're required to keep them on during the presentation. So hopefully it won't interfere too much with our discussion today, so please bear with us. I think we're going into our third year of this COVID crisis era, and for many of us, this online space is certainly becoming more familiar. But we still nonetheless hope that we're able to meet you all in person in the near future. And that said, we still very much appreciate this opportunity to discuss the topic today, even online. And we want to thank Legal 500 for working with us and organizing this opportunity. So the topic today is on the Monopoly Regulation and Fair Trade Act, which is Korea's primary antitrust law. And you will hear us refer to as Fair Trade Act or competition law in today's discussion, which recently underwent some significant amendments. And while we cannot cover all the changes in depth during today's discussion, we wanted to highlight some of these major changes, as well as discuss some updates on Korea's competition law enforcement trends for your benefit. So the primary issues that we're going to discuss today include information exchange now becoming a more significant factor in determining whether a cartel has occurred, the changes to the Korea's leniency system, as well as the process of allowing injured parties to seek preliminary injunctions for competition law violations, as well as changes to the standards in requiring merger notifications to KFTC and some of the other recent trends in regulation of online platforms in Korea. So on to the first topic on the issue of changes in the rule of how information exchange play in determining whether a cartel exists. And the subject of cartel itself has been relatively quiet globally in the recent years. But let me just pose this question to the panel and maybe to Hugh-Sik to start on what are some of these major changes and what's their significance?
The previous Fair Trade Act did not acknowledge collusion only for the reason of information exchange. However, according to the amended Fair Trade Act, just agreeing to exchange competitively sensitive information falls under the type of collusion. The definition of competitively sensitive information is very important. It includes price, output, cost, amount of delivery, stock, sales, terms of transaction, and terms of payment. It is highly likely that statistics disclosed in the market, consumer trend analysis, abstract business target, and financial data disclosed in the past will not be included in such competitively sensitive information. In addition, understanding the concept of exchanging is also important. Directly or indirectly providing information to competitor is generally included in the method of exchanging. In particular, exchanging a price increase plan through the industry trade association or market information company may fall under the collusion through the information exchange. Shannon, do you have any further comment?
Oh, yes. Under the old law, the Supreme Court position was that the agreement to exchange competitively sensitive information is not sufficient for finding of a cartel, such as price fixing, and presumption of a cartel cannot be made solely based on the information exchange. But under the new law, the agreement to exchange competitively sensitive information can be regulated as a cartel, but the KFTC still needs to prove anti-competitive effects from the information exchange. Also, the agreement may be presumed by existence of the external conformity of behavior, such as similar prices and output, and exchange of information necessary for such behavior conformity. Recently, KFTC issued detailed review guidelines on cartel involving information exchange. According to the guidelines, the agreement may be implicit, as in other types of cartel, and implicit agreement may be established if the competitively sensitive information exchange, number one, between persons with authority to make business decisions, two, frequently for a substantial period of time, and three, before making important business decisions. And finally, such exchanged information was actually used. So in order to assess the anti-competitive effects from the information exchange, KFTC takes various factors into account. For example, the degree of concentration in the relevant market, and the combined market share of the participants, duration, frequency, and timing of the information exchange, and purpose of the information exchange, etc. Because this cartel involving information exchange is a soft cartel, the anti-competitive information exchange may still be allowed if the efficiency enhancing effects from it outweighs the anti-competitive effect. So the KFTC's guidelines gave examples of exchange of cost information for joint product or technology development agreements between competitors. But I think we need to wait for the court's decision under the new law, and the court's decision will likely vary depending on the specific facts of the case.
Thank you, Hannah and Kishik. And for those who may have been following the developments of competition law enforcement trends just generally the past few years in Korea would know that economic analysis is becoming more significant, both in terms of reviewing major mergers, such as the Korean Air Asiana merger, as well as assessing damages in competition law violations, and with the KFTC establishing and operating its own economic analysis division. And we have here today Dr. Shin, who's the head of our economic analysis group. So Dr. Shin, if you will, to add another layer to this discussion, what would be the role that economic analysis can play in cartel violations that occur through information exchanges?
Well, Q1, as you probably know, economic analysis will become more difficult because under the new law, there is a presumption of an agreement with sensitive information exchanges, even when no evidence of an explicit agreement exists. I think the biggest change is the shift in the burden of proof to the defendants to show that information exchanges do not constitute an agreement. In previous cases, when an explicit agreement is not present, the KFTC has the burden of proof and must show that the information exchanges resulted in some form of external conformity in the market, such as changes in prices, quantities, capacity, or other market behavior. A typical economic defense tries to refute KFTC's evidence by showing that the accused firms did not act in a coordinated manner to impact the market. One way is to show that market participants' actions are not similar and do not show external conformity. For example, in a commercial truck manufacturer's cartel case, the KFTC did not have any evidence of an agreement, but there were exchanges of sensitive information on price changes and timing of launching new models. The KFTC attempted to argue that these information exchanges resulted in external conformity in price changes by showing examples of similar price increases during similar periods. As the testifying expert for one of the commercial truck manufacturers, I mapped all the price changes over time to counter that KFTC's claims were based on selective examination of the price changes and showed that there was no systematic external conformity in price changes, and that neither the timing nor the magnitude of price changes showed similarity across the commercial truck manufacturers. These firms were acquitted in Korea, but were found guilty of collusion in Europe. I must point out that Europe also assumes that the exchange of sensitive information is sufficient to show collusion. With the new law, the shift in the burden of proof makes it more difficult to show that there is no agreement among the defendants. Previously, defendants only had to show that the KFTC's proof of external conformity is faulty, and it was not difficult to do so. But now the defendants have to prove that there is no external conformity in the market, and subsequently that no implicit agreement existed. As you know, proving that something does not exist is much, much more difficult than proving that something does exist. So it would be worth keeping an eye on future collusion cases under the new law. We want to know how the Korean courts will decide on the question of what constitutes sufficient evidence to show that an agreement did not exist. Hopefully, our landmark case will systematically outline the proof that would be sufficient to show a lack of an assumed agreement.
Thank you, Dr. Shin. Cartel violation is obviously a serious matter for many of the corporations. And now that we have this new angle of information exchange and obviously additional burden and ability to avoid shifting the burden with economic analysis, maybe back to now Tana and Salman's next question. So what does it really mean? What will be the impact of these change that would mean for the corporations, and what are preparations that they can make in anticipation of these changes?
Yeah, for this topic, I'd like to pull up my slides. And as to the preparation for the new rules on information exchange, I would like to point out 3 measures, among others. First of all, we need to establish an internal information management system. The systematic information management to ensure that the entire competitive information is not shared is very important for any company doing business in Korea in the future. For example, when the employees attend the meetings with competitors, which I believe cannot be completely avoided in the real world, they are required to leave a written report before and after such meeting. And second, the close management of all incoming and outgoing information is also important. The sharing of sensitive information, such as price increase plan, through any means of communication, fax, emails, or meetings, is prohibited. And employees are required to refuse any proposals from competitors to share information, and more importantly, leave records of such refusal. So when the sensitive information, such as a price list or price increase plan, is shared to your business partner, appropriate warnings such as disclosure to other companies is strictly prohibited, needs to be included in writing. Third, specify the sources of any lawfully obtained competitor information is also important. The employees are required to specify the lawful background and source of any competitive information. The lawful means include market research, public disclosures, or legal materials. You may use the system as evidence supporting your company's responsible management in case of an inquiry from the authorities. For example, in most cartel cases, there are leniency applicants, and the authorities may obtain evidence on information exchange from your competitors. In such case, you may use the internal information management system supporting the company's responsible management, and even as a counter evidence. Thank you.
Oh, thank you, Hannah. We have so far discussed the issue of information exchange from the perspective of the cartel violation, but I just want to add one more comment that the risk of information exchange is significantly recognized these days in terms of many other aspects of business activities as well, such as the core marketing and collaboration between competitors, and even in the context of the M&As. For example, when company A pursues to acquire company B, which is a competitor to it, the M&A process inevitably involves the exchange of competitively sensitive information during the process of due diligence or preparation for post-merger integration. However, this may be potentially risky, especially if it is done before obtaining the competition authority's clearance, or if later the M&A is prohibited or abandoned. Therefore, it is highly advised that sufficient protective measures are taken during the whole process of the M&A. Such protective measures may typically include establishing clean team and clean room, so that comparatively sensitive information can be shared only through the clean room which can be accessed only by the clean team members. In this way, if the competition authorities raise any competition issues involving the information exchange later on, the parties can defend themselves by arguing that they took every necessary protective measures. Thank you.
Thank you both. And just picking up a little bit on Sang's last point, I mean, as a practitioner, I'm certainly working on a lot more matters recently with each of the members of the panel on clean team agreements, setting up clean teams, selecting members, setting up protocols. So it is certainly that you feel that it's becoming a bigger factor in today's corporate environment.
That's right.
So switching gears a bit now, and we talked about cartel and how information exchange plays. In maybe talking about ways, as I said, cartel violations is a serious offense that obviously everyone wants to avoid. But if the company were to investigate it or become involved otherwise in cartel other violations, there's been some change to leniency system under the revised rules. Chunyan, maybe you could start off on just talking about some of these changes in how it impacts companies.
Okay, sure. I'd like to point out a key change in leniency program. It is a revocation of leniency benefit. Under the amended competition law, leniency benefit may be revoked under some circumstances. The ground for revocation has been specified as 4 categories. First, when the leniency applicant's argument at the appellate trial negate a key element of statement or material that the leniency applicant submitted during the KFTC proceeding. And second, when it is proven at the appellate trial that a statement or material that the leniency applicant submitted during the KFTC procedure is false. Third, when the leniency applicant does not cooperate at the appellate trial in good faith without justifiable reason. Last but not least, when the leniency applicant file a lawsuit denying the cartel conduct subject to leniency. Can you share your thought on this?
Sure. I understand the reason for the amendment is that KFTC wants to secure the cooperation of the leniency applicants throughout the court proceedings. But there is a controversy over the subject or scope of leniency, that is, whether the admission of facts is sufficient or the admission of violations is required. Unfortunately, KFTC's practice has been leaning towards the latter. So in light of such KFTC's practice, second leniency applicants' litigation strategy will likely be affected by the amendment. For example, will it be still allowed for the second leniency applicant to argue against the legal implications, not the facts, at the court proceedings? Or will it only allowed to argue the degree of sanctions? For example, the administrative fine amount, which is reduced by 50% at the KFTC proceedings, the relevant revenue and the multiplier based on the gravity of violations are factors to the administrative fine amount. So the second leniency applicants can only argue at the court proceedings these factors only, or they can argue the legal implications of the cartel behavior. These issues will also need to be tested at the court finally.
Thank you. Thank you both for your input. It seems like we still, as with any new rule changes, we still do need to see some more guidance and interpretations by the courts and how these rules will actually apply. But Chunyan, if you will, can you clarify a bit more on whether violations of competition law results in criminal liability in Korea, and how does the leniency system work into such a process? And it'll be great to hear on the implications from Hyuna afterwards also.
Okay. Although the amended competition law limited the scope of criminal liability, still certain types of violation of competition law may lead to criminal penalty. It includes an abuse of market dominant position and an abuse of superior bargaining power, and of course, the cartel conduct. It should be also noted that prosecutor's office is actively pursuing investigation in criminal cartel cases. As you may know, the KFTC has an exclusive criminal referral authority under the previous competition law, but there was huge controversy whether to abolish this KFTC's exclusive authority when the National Assembly revising the competition law. But despite the debate, KFTC managed to retain its exclusive right to make a criminal referral in the competition law cases. However, although the KFTC continued to have the exclusive referral right, the prosecutor's office can conduct investigation without KFTC's criminal referral. It is because the referral is just only a requirement for indictment, not investigation. So when the prosecutor's office launched the investigation without KFTC's criminal referral, the prosecutor's office also can request for the criminal referral for indictment if needed. And recently, in December 2020, the prosecutor's office introduced its own guidelines on criminal leniency. The guidelines are for so-called hardcore cartels, for example, price fixing and bid rigging. I'm going to use my slide to show the difference between the leniency program of KFTC and prosecutor's office. The criminal leniency guidelines grant full immunity from prosecution to first-in-line applicants. However, second-in-line applicant does not get full immunity. They can only get reduction in demanding the level of punishment by the prosecutor. Meanwhile, the KFTC's leniency program had effectively exempted first and the second leniency applicant from criminal punishment. That is a big difference. And the criminal leniency guidelines allows individual applicants to be granted leniency. It differs from the KFTC's previous practices since the KFTC does not have leniency program for individuals. The criminal leniency guidelines give considerable incentive for individuals, especially for retired employee, to apply for leniency. It is probable that companies and its retired employee compete for leniency. As for current officers and employees, they can get exempt from criminal punishment along with the company when the company applies for criminal leniency. These two leniency programs are totally independent from each other. So it should be noted that applying for one leniency program does not guarantee benefit from another. Hannah, what will happen after this new guideline?
I guess prosecutor's office's more proactive environment in cartel enforcement is anticipated, and more cautious approach is required when companies decide whether to apply for leniency. We have a new president-elect who is ex-prosecutor general. It is still unclear whether the prosecutor's office will become more active or take more cautious approach, at least during the early presidential term. We'll see how it would unfold in a few months to come. The companies need to assess the impact of the leniency by individuals. For example, as Junior mentioned, retired employee with prosecutor's office on the company's KFTC leniency application. There may be some conflict of interest between company and retired employees. Their leniency application with the prosecutor's office may make it difficult. Companies' cooperation with the KFTC. But the incentive to apply for leniency with the prosecutor's office is that the exemption from compulsory investigation, such as arrest, search and seizure for the applicant is granted. However, in case of the second leniency applicant, their benefits are not granted by the prosecutor's office because it is the court who has the authority to make a final decision. It's one of the differences from the KFTC leniency program itself. Therefore, in most cases, leniency application with both KFTC and prosecutor's office is recommended. And lastly, another important point to remember is that companies now need to be prepared for additional review by other authorities as well. The grant of leniency status by the KFTC does not completely exempt the criminal punishment now. There are 3 other authorities who have the right to request the KFTC to make criminal referral. Upon such request, KFTC must make criminal referral. In particular, nowadays, Ministry of SMEs and Startups, 중소기업청, are becoming more and more active in requesting KFTC to refer the case to prosecutor's office.
Great. Again, thank you both. I mean, as if the original leniency program wasn't complicated enough with the involvement and the interplay between the KFTC and the prosecutor's office. I think now with the prosecutor's office exercising their own leniency program, I think it really just does further make the process more complicated. But I think just important to remember is just it is a very fact-specific process, but something that you need to think about early on with your counsel. I think if you're involved in a cartel investigation as an option. So, but switching again, focus on to another part of an investigation. There's the criminal. We talked about the criminal portion. There's now the private action that usually follows violations of competition laws. So, Chunyan, can you tell us a little bit about how officers and employees for a company can bear civil liability for violations of competition laws that was actually undertaken by another officer or employee? So not themselves, but another employee of the company, and they weren't themselves involved in this cartel conduct.
Yes. Yeah. To answer your question, the answer is yes. Officers and employees can bear civil liability for the company's violation of competition law, which they did not personally participate in. Nowadays, private enforcement of competition law in the form of shareholder deliberative lawsuit is constantly increasing in Korea. As you may know, the shareholder deliberative lawsuit is a lawsuit brought by a shareholder or group of shareholders to assert a claim belonging to the company against directors or officers who caused harm to the company. We can see more and more cases in that claiming damages which incurred by administrative fine resulting from the investigation of cartel conduct of the KFTC. Moreover, in a shareholder deliberative lawsuit case, the Seoul High Court held that the directors or auditors are liable for failing to monitor and supervise the act of a company's officer or other directors who engaged in the cartel conduct and caused harm to the company. According to the court's decision, even though a director did not actively engage in the conspiracy, and even if the director did not know or could not know the specific violation of the law, and there was no circumstances to suspect it, if there is no reasonable internal control system to prevent illegal acts such as price fixing, and a director fails to make effort to build and implement those internal control systems, then the director will be liable for the violation of his or her own duty to monitor and supervise. I think that the most important takeaway from this case is that a director cannot defend themselves by merely asserting that she or he did not know or could not know the illegal act. The director should prove that he or she made an effort to build and implement the internal control system to prevent illegal acts. I think that that's why the company should focus on the compliance system. Thank you.
Thank you, and I fully agree, especially when a lot of the companies operating in Korea have directors or officers that are located outside of Korea, away from the business people, especially legal. It's sometimes very difficult to be hands-on to all the ongoings of the company, but this does demonstrate that you still are required to make yourself aware of the things that are going on, at least having system so that you're aware of the communications and then the activities of your business people. So thank you for that clarification. So Chunyan, another question. So also in connection with the improvements that we talked about civil litigation system for competition law violations and the burdens, as I understand, as I mentioned at the beginning, is that now Korea, as a sort of a ex ante protection of competition law violations, are now allowing for injunctions from the court to stop or prevent damages from occurring from competition law violations. And now parties that are claiming to be injured or potentially injured could file for these injunctive relief. So can you provide a bit more, and those are just quick overview, a bit more color on the procedure, including the types of conduct that would be subject to such injunctive relief?
Okay, sure. In the past, an injunctive relief at the court is very hard to get, even if the injunctive relief itself is theoretically possible under the Civil Execution Act. Also, even if victim accuse perpetrator of unfair trade practices to the KFTC, KFTC can impose administrative fine or corrective order only after the harm has already occurred. Accordingly, victims had difficulty in seeking remedies that can prevent imminent harm in a timely manner. Now, the amended competition law explicitly allow parties harmed by unfair trade practices such as refusal to deal and abuse of superior bargaining power, etc., or the act of trade association, which facilitate or solicit the unfair trade practices to directly seek injunctive relief at the court against the perpetrator. This permits private parties to promptly seek suspension and prevention of infringement by asserting and proving the injuries that they have sustained or are likely to sustain due to unfair trade practices. So they don't have to wait until the KFTC launch the investigation and renders its decision on the case. But it should be noted that the amended competition law is silent on whether violation of the competition law other than unfair trade practices would be subject to injunctive relief. It seems that it will be difficult for victims of other types of violation to use the injunctive relief without explicit provision in the law. Hannah, what do you think of this new procedure?
I think this new process can be utilized, but with some hurdles. First, a court decision in injunction case will likely have substantial impact on the KFTC's following investigation on unfair trade practices, because the court made anyhow a preliminary decision on the illegality of the conduct, and in the injunctive relief may become more efficient and effective means for the counterparty to unfair trade practices compared to other existing measures. For example, the distributors may actively claim an injunction against the supplier as a leverage in the negotiation process, particularly when their relationship soured and the supplier wanted to terminate the contract. Currently, the distributor may choose two measures, mainly. One is the filing of a complaint with the KFTC, and the other is a file for mediation at the Korea Fair Trade Mediation Agency. The first measure, the KFTC investigation, takes a long time to get the goal of stopping the conduct at issue. In this case, the refusal to deal, the termination of the contract. Because after the investigation, the supplier may file appeal with the court, and the court procedure would take a long time as well. And the mediation at the Korea Fair Trade Mediation Agency, so-called KOFAIR, the agency does not have the authority to decide whether there are violations of the antitrust law. Because the mediation at the KOFAIR is a purely voluntary process, so it is effective only if both parties want to settle the case. So it is by no means a solution for finding a violation of the antitrust law. Although there is no explicit provision Similar to injunctive relief in civil cases, the claimant may also need to prove additional requirements, such as irreparable harm from the unfair trade practices at issue, and such harm cannot be cured by monetary compensation. So we need to wait for the court decision on how the courts will interpret these two additional requirements for the injunctive relief case.
Thank you. It is certainly an interesting development. Obviously, the goal of any antitrust agency would be to balance ex ante prevention of harm as well as ex post remedying such harm or imposing fines to prevent further harm from occurring. And we just hope that this new development of introduction of this injunctive relief will help in balancing the approach by the KFTC. And also the reason we wanted to bring this up was, as with any new procedures, we wanted to highlight that this may be a new tool for you in exploring any harm that you may be suffering from competition law issues, but that there also may be parties that are seeking to abuse a new system, so that you are aware of that. And as Hyuna mentioned, we're still looking to see how this will actually develop, but that you may be on the other end of an injunctive request, so to prepare accordingly in that context. So thank you all for your feedback. So let me now move on to our next topic, which is in the area of changes to merger control rules. And for this, I'll move back onto this side of my table to my colleague Sang-Hoon, who's very much a specialist on this issue. We like to think that we are, but especially Sang-Hoon with his background as a former KFTC case officer. So Sang-Hoon, can you tell us a bit about how the new rules have changed and maybe a bit of overview on the KFTC's trends in terms of merger review?
Thank you, Kyun. Let me use this slide to show how the merger filing threshold is changed. So as you can see in this slide, there were two scenarios where a merger filing is required under the previous constitutional law. So first, if it is a domestic transaction, there is a size of party threshold where one party should have total assets or global revenue in the amount of 300 billion Korean won, which is about $250 million or more. And the other party should have total assets or global revenue in the amount of 30 billion Korean won, which is about $25 million or more. And second, if it is a foreign to foreign transaction, then there is a additional threshold based on Korean turnover on top of the two previous elements. So the third element here is the respective foreign parties should have Korean turnover generated in Korea in the amount of 30 billion Korean won or more. And now with the revision, there is a additional threshold based on the size of transaction. So if the transaction involves a small target company whose size is less than 30 billion Korean won, then previously this transaction was not reportable. But now, if the two additional elements are met, then this small target transaction will be still reportable. So first element is that the transaction amount should be 600 billion Korean won or more. And the second element is that the small size target should be engaging in a significant business activity in Korean market. So what is the significant business operation activity in Korean market? So the KFTC announced a guideline to specify this element. And this element is satisfied if either of the two situation exists. The first situation is during the past 3 years, the target has provided services to 1 million Korean people or more per month. And the second scenario is that during the past 3 years, the target has maintained an R&D facility and researchers in Korea spending 30 billion Korean won or more per year. So as you can see from the newly introduced threshold, this revision is targeting so-called killer acquisition, where a global giant IT company acquires a promising venture company in its early development to abolish future competition with the venture company. As there are more M&A transactions by the IT-focused global giants, which are dominant by controlling its own platform, this is one of the efforts by the competition authorities throughout the world, not only by the KFTC, to regulate the expansion of the platform monopoly. So since it has been only 2.5 months after the revision, we do not have the case where the additional threshold is applied. We need to wait and see how many more cases will be reported by meeting the newly introduced threshold and how the KFTC will conduct its merger review in these cases. Given this, I think Dr. Shin can give us a hint about the KFTC's approach in reviewing these merger cases. Dr. Shin?
Sang-Hoon, I'm going to deal with platforms actually. Platforms such as traditional marketplace where sellers and buyers come together in one location have existed for a long time. Technology, however, transformed this type of traditional platforms to online digital platforms and eliminated the physical capacity constraints. Now, online platforms provide efficient solutions and benefits to consumers in nearly all aspects of our daily lives. Now, you think about ordering of food, ordering meals, ordering groceries, calling a cab, all can be done through an app on your telephone. However, these multi-sided platforms involve complicated interactions across various sides. So it is often difficult to understand or model platforms' unique features, such as multiple sides, economies of scale and density, direct and indirect network effects, switching costs, multi-homing costs, and so on. These are all big terms and very difficult to understand or model or estimate. So in addition, platforms typically include a free side, which are more difficult to model than the traditional price-reliant markets. So FTC has been using traditional antitrust tools in evaluating not only the regular mergers, but also on digital platform mergers. These include critical loss analysis, diversion ratios, upward pricing pressures, and other variants such as guppy, and surveys of consumers and businesses to model their behavior. So, as you know, defining markets is typically more difficult on online platforms because of because KFTC has to evaluate not only the platform competition, but also the individual size of the platform. For platform sites that have zero price, the KFTC has relied on membership information and used consumer surveys to model and evaluate promotions and coupons impact on consumer behavior. So even though there are no price, these promotions act as a pseudo price for KFTC to evaluate the no price side of the market. On the pay side, the KFTC has relied on surveys to model business behavior and use critical loss analysis and upward pricing pressure analyses. Often, these traditional methods offer valuable insights of market definition as well as on competitive effects. So additionally, the KFTC will likely examine the merger's impact on innovation, privacy concerns, and concentration of large data sets. And that has to be wait until our next seminar. So let me end this answer with the example involving a merger between two platforms. As you can see on the slide, Delivery Hero with Yogiyo, Yogiyo is the second largest, attempted to acquire Baemin, which is the largest restaurant prepared food delivery platforms. In December 2020, the KFTC approved the deal with a condition that Delivery Hero's Yogiyo be divested. And Delivery Hero accepted the condition and consummated the merger. So essentially, this merger allowed number two player to acquire number one and become the number one player in the market, but had to divest its own assets to make sure that number one and number two remain in the marketplace. So in evaluating the merger, the KFTC used critical loss analysis to develop a relevant market, define a relevant market, relevant product market, I meant. They also used guppy to examine consumer competitive effects. So on the restaurant side, KFTC relied on simulations to show that a 5 to 10% fee increase will result in a loss of less than 1% of the restaurants switching to other platforms. So both sides would suffer competitive harm if the merger were to be approved. Hence, the KFTC made its conditional approval, keeping both Yogiyo and Baemin platforms in the marketplace.
Thank you. And with Salman's point on the new size of the test requirement, I think I remember conversation first coming up on the WhatsApp Facebook merger, and everybody thinking, how did that merger get away from us?
Yep.
And it's great to see it's finally an impact. And despite all the promotions or other publication materials, I just even had a comment last week from another potential client asking, who's very well aware of Korean's merger requirement, but he wasn't aware that this size of test transaction test has gone into effect, so you have to explain it to him. And so now that you've heard and you should be aware in any potential mergers that this is a new requirement. So thank you all for your insight. So that connects into sort of what we want to talk about. So KFTC again is very much aware of these new I guess industry, the online and platform and sort of the new industry, and they reported in its operational plans to the President's office earlier this year, which includes, among others, improving regulations and enhancing investigation in these new online platforms, and also conducting surveys in so-called new industries like online marketplaces, electronic vehicles, batteries, and delivery apps regarding potential unfair fair trade practices or issues in the subcontracting process. As we mentioned, we have a new president. It's a very recent phenomenon, so it's to be seen whether the plans will actually continue, but that's the plans that reported as of earlier this year. And in connection with such plans, my understanding is that the KFTC also has been actively investigating online platforms and so-called big tech companies like Google. So again, on my right side, so Kishik, Simon, and Richard, maybe you could give us your thoughts on some recent examples of the KFTC's enforcement against such large tech companies.
Okay. Let me first start with talking about the KFTC's organizational preparation for the enforcement in this area. As we all know, the KFTC has been very active in regulating global IT giants such as Microsoft and Qualcomm since the dawn of the 21st century. One of the main reasons how the KFTC achieved a successful outcome in these landmark cases from their perspective is that the KFTC set up a case team focusing only on the case, only on the investigation of that case throughout the long investigation without being interrupted by the periodic step reshuffling. Taking lessons from these past experiences, the KFTC established a task force focusing on regulating ICT industry back in November 2019. This task force targeted three subsectors such as online platform, mobile, and IP rights, and later expanded their interest to app markets, digital advertisement, and semiconductors. Along with the organizational changes, the KFTC is actively conducting an in-depth studies to understand the industry and engaging in international cooperation and communication with the market players as well. A series of recent enforcement in this area is the achievement of this task force. Dr. Shin, can you tell us about some exemplary investigations by the KFTC in this area?
Sure. Recently, the KFTC investigated and sanctioned Google, Netflix, and Naver, Korea's #1 internet search platform. Since 2016, KFTC has been looking into Google over allegations it obstructed local smartphone makers, such as Samsung Electronics Company, from using operating systems developed by rivals. The KFTC decided that Google has hampered market competition by requiring smartphone manufacturers to sign an anti-fragmentation agreement when they finalize key contracts with Google over App Store licenses and early access to Android OS. The practice has helped Google gain its market dominance in the mobile platform market and undermine innovation in the development of new OS for smart devices. The regulator has ordered Google to ban its practice of forcing Android manufacturers to sign an AFA and to make corrections. Sorry about that. My prepared comments have just disappeared from my iPad. And so this is what happens when you rely on too much on technology. So I will ask Sang-hoon to provide with the better. All right, so the regulators have ordered Google to ban its practice of forcing Android manufacturers to sign an AFA. So I'm repeating myself here, and to make corrections on details about the AFA before reporting them to the commission. But in February, Seoul High Court has decided to suspend the KFTC order until August 31st, stating that a deferment is necessary to prevent irreparable damage to the plaintiffs. So Kushik, would you continue with Neighbor and Netflix investigations?
Sure. I'm gonna show one slide. Yeah, I want to talk about Neighbor and Netflix case. In October 2020, the KFTC issued a corrective order and imposed an administrative fine against Neighbor, which is a popular Korean online platform. After the investigation, the KFTC concluded that Neighbor had abused its market dominant position, especially self-preferencing. First, Neighbor exposed its online shopping mall products first in search result over other companies' products. Second, even though Neighbor changed its video search exposure algorithm, Neighbor did not inform such fact to other video providers, so other providers' contents were not exposed to the high rank. In addition, the KFTC reviewed the consumer terms and conditions of video streaming operators, including Netflix. After the investigation, the KFTC imposed corrective action on following matters. First, when streaming operators change the subscription rate policy, they must obtain consent from consumer. Second, even though if the consumer requests a refund during the contract period, the refund should be made immediately. Considering recent KFTC investigation trends, we expect that the KFTC scrutiny on online platform business will intensify. Thank you.
Thank you. And obviously, we're now talking about new industries where we're facing interactions that didn't exist under the traditional brick and mortar marketplace. And obviously, KFTC does still continue to utilize the existing tools, but what about from the perspective of changing the existing regulations and adopting them or enacting new laws over these online platforms to support this increased effort by enforcement effort by the KFTC? Are there any maybe the panel could talk about whether there are any ongoing such regulatory efforts with maybe we should start off.
Yeah, I'm going to show one slide. Recently, discussion on how to regulate online platform operators are actively underway in Korea. Currently, a bill on the fairness in online platform intermediary transactions act is proposed to the National Assembly. This act is under the control of KFTC. This bill intended to regulate unfair business practice between large online platform operators and vendors who are selling their product or service through online platforms. It established several prohibited behaviors. First, forcing a vendor to purchase goods and service from the online platform operators. Second, compelling disadvantage to vendor. Third, self-preferencing by manipulating ranking in exposure of search results. Fourth, most favored nation clause. In addition, this bill imposes an obligation on online platform operators to provide a contract document to online vendors before they start brokering transactions. It is under discussion that this bill will apply to online platform with a sales amount of at least 100 billion won or the brokerage transaction amount of at least 1 trillion won. In such case, Google Play and Apple App Store are expected to be subjected to the law. Next, Next. In addition, the bill on the Online Platform User Protection Act is also proposed to the National Assembly. This act is under the control of the Korea Communication Commission. This bill regulates the relationship between online platform operators and individual users. And one more, the KFTC established a guideline for review of online platform operators' abuse of market dominant position. This guideline clearly categorizes which behaviors of online platform operators constitute violation of the Fair Trade Act. For instance, prohibiting virtual homing, most favored nation clause, statutory currency, and time. That's it. Thank you.
Hannah, do you have any thoughts?
Oh, yes. I understand there has been a lot of discussion on this new online platform regulation, and it already took a long time to accommodate the positions of the two different authorities involved, the KFTC and the KCC, and other various interested parties. However, the future of this new legislation is still unclear. It was led by the current progressive administration. Now we have the new conservative administration, and it will heavily be affected by the competition policy of the new administration, which will likely much differ from the current administration. At the same time, because the Progressive Party still has the majority seat at the National Assembly, it will take a lot of time if the new administration to revise the draft bill and carry through its new competition policy by the new legislation. Having said that, the new administration may try to implement its new policy through the current competition law, not advising or not introducing any new legislation, because it is possible under the current competition law as well.
Thank you both. And I also understand that there's a discussion to amend the Act on Protection of Consumer on Electronic Commerce, which is another law that we're talking about. Simon, so can you just talk about some of the major changes there?
Okay, so that law is abbreviated as the Electronic Commerce Act. And since the enactment in 2002, that Electronic Commerce Act has focused on protecting the rights and interests of consumers in electronic commerce transactions. Thus, while the Online Platform Act proposed by the KFTC recently focuses on the relationship between the online platform operator and the sellers who sell their products on the platform, the Electronic Commerce Act has focused on the relationship between the sellers and the consumers. Now, as online platform services advanced, it became evident that the traditional approach of the Electronic Commerce Act focusing on the relationship between the sellers and consumers has clear limitation because it did not give sufficient emphasis on the status of the online platforms as the intermediary in realizing the transaction between the seller and the consumers. So earlier this month, the KFTC announced the proposed revision to the Electronic Commerce Act, focusing on the roles and responsibilities of the online platforms. For example, under the proposed revision, the online platforms should disclose major standards to determine the search outcome and take joint and several liability with the sellers if there is a consumer harm. Other than this, there are several bills pending before the National Assembly, so we cannot guarantee specifically what obligations and prohibitions will be eventually included in the final amendment. However, roughly speaking, we can surely expect a tougher regulation against online platforms in this perspective as well.
Thank you. So on continuing on that point is maybe on a more hotter topic is, the in-app purchase requirements by Google and Apple, as well as their closed app market policy, which is certainly on the focus globally, including the United States with the movement to enact the Open App Markets Act. Kyushik, so can you give us your thoughts on how the Korean authorities have been reacting to the issue, including any regulatory efforts?
I want to. Yeah. The amended Telecommunication Business Act is prohibiting market operators from forcing a certain payment method. This act established several prohibited behaviors. First, technically restricting the use of another payment method. Second, making the use of another payment method procedurally difficult or inconvenient. Third, imposing unreasonable discriminatory terms or restrictions regarding payment processing fee on mobile content provider or consumers who use another payment method. After the Telecommunication Business Act was enacted, Google and Apple expressed that they would voluntarily correct in a payment policy and will allow third-party payment systems. However, according to the media reports, there is still controversy over whether such voluntary remedy conforms to the Telecommunication Business Act or not. In 2020, the Startup Association filed a complaint against Google to the KFTC. But the KFTC currently defers its investigation of Google because there is a possibility that in a payment issue can be resolved by the enforcement of amended Telecommunication Business Act. However, if Google's voluntary corrective action is deemed insufficient, the possibility of the KFTC starting an investigation into Google cannot be ruled out. Thank you.
Thank you, everyone, all the panels today. We are now a little bit over time. So just to wrap up our discussion today, Junya, maybe can you give us some parting thoughts on how companies that are either operating in Korea or have exposure to Korean competition law issues can prepare or react to these changes?
Okay. Sure. First of all, I think that the global companies doing business in Korea need to keep paying attention to the trends of new legislation as well as the ongoing KFTC investigation. And of course, the companies need to check their compliance system according to these trends. And also, I want to say that the global development or global regulatory development on the online platform market is also important. This is because the KFTC also keep an eye on the development of the other countries and the result of investigation by foreign competition authority like US or EU. So companies are recommended to catch up the development of the global regulation on the online platform market. And lastly, I'd like to emphasize that even if the bills in the National Assembly is not actually enacted or delayed, the government still can regulate the companies by just applying the current competition law. So in other words, regardless of whether the various pending bills are enacted or not, the companies need to enhance their own compliance system. Thank you.
Thank you. So that wraps up our discussion part of the presentation today. And I think we have time for some questions.
Yeah, that's right. We've got a couple from the audience, but first I wanted to ask if Nicole had anything to add to the discussion. So.
Yeah, I actually do have a quick one. Thank you, BKL team, for the presentation. The overview was really helpful. You've already mentioned a little bit on the online platform regulations, but given that we now have a new president-elect, Mr. Yoon, and I guess considering his position in a more liberal approach, I'm curious to hear your views on whether we can anticipate any changes in the enforcement of competition laws and any further legislative movement in the Online Platform Act.
Thank you. So we have certainly, let me address that question. We have touched upon it a little bit, I think, during the presentation and discussion part, but it was, if those who have followed, it was one of the closest elections that I've seen. You know, the percentage difference ended up being less than 1%. So we have a very, very much a bipartisan government right now. And so it's certainly to be seen whether any of the campaign promises that the current president-elect will be implemented. But this certainly does represent a transition from a progressive government into a conservative. Although, for at least for the competition perspective, the current policy statements from President-elect Yoon doesn't suggest that he will pursue any sort of sharp changes in direction, although he is likely to moderate the KFTC's activity in some respect, and with the emphasis on the enforcement being on a more reasonable basis. So as mentioned, he's a ex-prosecutor general, so the dynamic of the KFTC between the prosecutor's office, and obviously there was some struggle between the two agencies in terms of who has the right to enforce criminal enforcement, which is a very important tool in Korean competition law enforcement. So we will certainly see some developments, I think, on that regard and how that plays out. The focus under the current administration was to aid the so-called weak party, and because of the existence of conglomerates, suppliers and subcontractors, these large companies have already traditionally been considered a weak party. And their focus was on protecting these parties and a variety of situations that demonstrates imbalance in bargaining power. This is likely to continue under the new administration. And he also, as I mentioned, he did advocate some constraint on the KFTC's discretion to pursue criminal penalties. But he has also been very much focused on abuse of dominance and large party exercising abusing their authority in the market to the detriment of other participants in the market. So we'll see, I think, some movements in that regard as well. Some of the more notable promises are, again, mentioning that requiring the KFTC to pursue criminal prosecution in a more fair and objective manner. And also, he said he plans to push for legislations that will set up an integrated system of mediation. So rather than opposed to strict investigation and more adversarial proceeding, he will certainly look to pursue more mediation as an alternative dispute resolution tool in competition law issues. He also said he plans to introduce a price sliding scale system that links prices of the products to production costs, which what that means is it will reduce the price burden on subcontractors and suppliers if there's a change in raw material costs, so that the price is ultimately borne onto the final company that sells the product. So obviously, again, to talk about the weaker party versus stronger party and not have these smaller SME suppliers or subcontractors be exposed to the price changes. In the digital platform sector, he said he would rely primarily on self-regulation, but let me just clarify that point is, it is not to say he will just, and we talked a lot about how online platforms are being regulated. It is not to say he's going to sort of divert from the efforts they've made against large tech companies and online platforms. It's just to minimize sort of minor regulatory burden in businesses and foster market dynamics and innovation. But that is not to say if a large company that has dominance in the position in the market is abusing such position that the administration will say, well, we're letting you self-regulate. I mean, I think there will continue to be enhanced enforcement efforts in that regard. But I think one of the promises he did make was to relax some of the minor restrictions to foster innovations and let the market sort of cultivate itself. On a sort of a minor point that may not be necessarily significant to foreign operators would be, he also promised to relax the rule on the scope of defining familiar relationships in a related party for the purposes of enforcing fair competition laws. Again, those who may be aware of Korean marketplace and sort of the history is a lot of the conglomerates are family-owned businesses, and defining family relationship was an important part of competition law enforcement because a lot of the subsidiaries and affiliates are owned by blood relations. So his promise to relax the requirement also demonstrates his, I guess, preference on further sort of lessening the regulatory environment for large corporations in operating in Korea. So at least, I mean, it's appeared to be somewhat business friendly. Again, just to be seen whether they'll just remain in his agenda and focus as we move toward the transition committee in I guess, prioritizing the campaign promises, and with this bipartisan government that we talked about, it is certainly to be seen, but these are some of the major points that he at least promised during his election process. We have also outlined various other industries and his campaign promise is on our website, so you can certainly go check it out. If you want to look into other industries like finance, tax, labor, we have put out a blurb on summarizing Yoon's campaign promises. So hopefully, maybe you can find some information there that you might find helpful as well.
Yes, interestingly, he mentions that he makes the government as one of the platforms. So he's from
Okay.
platform government.
I would certainly like to see how that's actually going to be in real life. But, so
I guess there
hopefully,
is a bit of hope there. Thank you. We'll definitely be following closely.
thank you.
Excuse me. Cool. So we had another question, which is asking your opinions, really. What's your viewpoint on the recent regulation by the KFTC against online platforms? Because there has been some criticism, I believe, that it's overly harsh. There's undue emphasis on protecting consumers or marketplace participants without thinking about it from the business's point of view, whether it can foster innovation or balance in the market. So yeah, I was wondering if you had any thoughts on that.
Okay, let me take that question. In my personal opinion, the such kind of criticism focuses on two aspects. So first, the KFTC was in such a hurry in introducing new regulatory regimes, considering the competition with the KCC, Korea Communications Commission, for the jurisdiction of the platform economy, not only from the regulatory and the legal aspects, but also in the enforcement aspects as well. So in this regard, the same criticism should go to the KCC as well, as this duplicate regulatory issue has been one of the main reasons why the legislative process has been further delayed so far. Second, the KFTC took the regulatory frame first without waiting for the developments in industry dynamics. Therefore, the Online Platform Act cut and pasted many typical types of unfair trade practices from the traditional competition law without carefully considering the unique dynamics of competition in online platform industry. Nonetheless, I assess positively that the KFTC's effort to conduct an in-depth study to understand the online platform industry is going on, as I mentioned during the panel discussion. So the KFTC is well aware of the criticism by the industry and tries to understand more the industry dynamics. So I think also with the new administration, with a more generous approach to the business, the KFTC will put a priority to solve various legal and regulatory issues to come up with the most appropriate policy package. Thank you.
Thank you very much for that answer. I had one other question, actually, if that's okay. So we've had the criminal leniency guideline from the prosecutor's office for about 1 year now. I was wondering if anyone had any thoughts on how that's being utilized in Korea currently.
Okay, I think that we can share our experience on the during the past 1 year after the criminal leniency is introduced. Actually, we, the BKL team, has some experience for filing or the analyze to whether to file the criminal leniency for the clients. And also, in last fall, in September 2021, we had the very first case that the criminal leniency guideline is actually applied. In that case was a bid rigging case, and in that case, the prosecutor's office exempted one company from indictment, and indict all the other companies. That company was the first in line leniency applicant. And I remember that when that case was closed, the prosecutor's office announced that that is just the beginning of the more active application of the criminal leniency guidelines. So I think that the criminal leniency is not something that we will face in the future. Rather, I think that the criminal leniency is something that we have to deal with right now.
So thank you, Chunyan. Seems like we have a couple of anonymous questions. Since we have a little bit of time, maybe we could address them. And now I'm happy to share my thoughts, and panel members could just jump in. The first question is, can the Korea Fair Trade Institute be considered a trustworthy mediator by non-Korean companies? Well, at least from my perspective, I mean, I've never really, and I do represent primarily foreign companies in proceedings before the KFTC. Never felt that just because of the virtue of the fact that they were foreign companies, they were discriminated against. And Sang-won is perfect to respond, because he was a former case officer, but because most of the cases, the representation is made through us, a Korean law firm, we haven't really seen, I personally haven't seen a case where we felt like they were being unfairly treated because they were just by virtue of the fact that they're a foreign company. I have seen cases though, where there may have been some difficulty in understanding KFTC's proceeding by a foreign company, because they were generally the larger manufacturer and they're operating in Korea through a smaller distributor or supplier, which then, going back to talking about the imbalance of power, the tendency of the KFTC is to protect the so-called weaker party. And so the foreign operator that are operating, obviously unfamiliar with the market and some of the business environment, may have felt like they're being treated. But in terms of the fairness of the agency, I personally haven't felt that just they're discriminating against foreign company just by virtue of that fact. So I mean, Sang, do you have any thoughts?
Yeah, Kyun, I agree. I totally agree with your comments. And this is also one of the most frequently asked questions
I know, right?
to me by foreign clients. And let me give you just two comments. First one is that it seems that the KFTC is focusing investigation on very big name foreign global companies doing business in Korea. But it is just because they are successful in Korea, as well as they are successful in the world as well. So because they have a very kind of a important and very dominant position in Korea, they may get more attention from the KFTC. That's one comment. And second, procedurally, the KFTC is also recognizing the various criticisms from the foreign companies in the KFTC's procedure to ensure the fairness. So the KFTC is constantly trying to improve their procedure to enhance the fairness. So one of the recent efforts by the KFTC is to set up a document review room where the companies, not only domestic or but also the foreign companies, can send their external counsel to review documents that are usually protected from the review by the company, because of the provider of that document has the trade secret issue or may fear about retaliation by the company. So using this document review room, the external counsel of the company can review the document without being protected by the other parties, and they may enhance their right of defense. So this is one of the measures taken recently by the KFTC, and I'm sure that the KFTC is taking various comments from the legal community and also business communities to further improve their procedures. Thank you.
Yeah, I think personally, the issue here is maybe the structural limitation of the KFTC, because there are in the same body of the agency, there are investigation parts and the deliberation parts under the same roof. So there is no truly independent decision-making process. In such an inherent structural problem, there are some due process issues raised by not only by the foreign companies, but even by the domestic companies as well.
Certainly.
So that's the fundamental issues. But other than those fundamental issues, there has been a lot of developments in due process at the KFTC.
Right.
Great. So thank you for your thoughts on the question. It certainly seems like we all have experience in the question. So it's very reasonable that we see this question pop up from the audience. So another question, and that is the last question that we have time for, is whether, on the point of injunction remedies, whether the injunctions are only granted after competition law infringement has already happened, or is it sufficient to prevent the creation of monopolies, et cetera. So my understanding obviously is that there is a burden of proof that the party seeking injunctive relief has to show that there's imminent and irreparable harm that's about to occur, barring the granting of injunctive relief. Otherwise, again, it's still being granted on a limited scope only for unfair trade practices and not for abuse of dominant position. So I don't think we're really worried about the creation of monopolies in these cases here. What's traditionally defined as unfair trade practices in Korea will be subject to injunctive relief. So it's not for every types of behavior, but the party seeking injunctive relief does have the burden of proof that they need to be granted this remedy to prevent harm from occurring. Otherwise, there's no other possible. There's no, I guess, ex post rectifying of the harm that could occur. And this injunctive relief, as I said, there may be certainly parties seeking to abuse the system to stop the other party from operating their businesses, which may cause, again, harm on their side if they're given the injunctive relief to not be able to take the conduct that the party claiming is trying to prevent. So that's my understanding that it's, again, it's still
as a prevention of the creation of monopolies, I think the merger review has something to do with it, because apart from the M&A transaction that could create monopolies in the certain relevant market, there is no rule regulating the monopoly itself. The behavior or conduct of the dominant player is regulated, but the creation of the monopoly itself is only regulated by the merger review.
I mean, even if there was to be a monopoly, I mean, the monopoly existence in and of itself is not necessarily a violation. Like they generally take conducts to maintain or enforce the monopoly, which the competition laws are intended to protect. And it's almost inevitable if somebody, in a free market system, somebody does overtake that kind of position. It's always hard to see that, it's just because their products or services just so far and above and beyond what anybody else can offer. I mean, we do see typically in that context, actions have been taken to sort of solidify and maintain that monopoly, which is where the competition law would come in. But the creation in and of itself wouldn't be the realm.
And I want to add one comment on that. Actually, the many people point out that the Korean competition law has two goals. One is typical goals: prevention of the monopolies and prevention of the anti-competitive harms. But the other goal, the other important goal is that to protect the weak parties. So and to maintain the fairness of the transaction.
Right.
Yeah. And I want to stress that the introduction of injunctive relief is intended and enacted for the purpose of protect the weak parties, not prevent the monopolies. So we can see that in the point that the current law state that the injunctive relief is only for the unfair trade practices, not for the abuse of market dominant position. So and for the abuse of market dominant position, the Korean law, Korean Supreme Court required the anti-competitive effect. So in accordance of that position, I think that the injunctive relief cannot be expanded before the amendment of the law to the abuse of market dominant position outside of the unfair trade practices.
Yeah, but theoretically, it's still possible under civil proceedings systems, but it will be more heavily used by the victims of unfair trade practices. As Junior mentioned, it is targeted to enhance the fairness of the competition system, not the anti-competitive effects in the relevant market is the target of this new system. So let's see how it expanded in the future, but at least under the current provision of the revised competition law, the injunction relief may be available only for unfair trade practices.
So thank you, panel, and thank you for the anonymous participant who posed us interesting questions. It was certainly our pleasure to be presenting and speaking with you this afternoon, and thank you for listening despite the time now being after business hours. So again, appreciate the opportunity, and thank you, Legal 500, for organizing the event.
Yeah, thank you so much, guys. Really, really interesting topic there. So thank you very much for your efforts. And yeah, we'll see you all soon. Just to remind everyone, this is a Legal 500 and BKL webinar, and we'll see you all again next time. So thanks very much and good night.
Thank you, everybody.
Thank you.
Bye.
Bye-bye.
Bye.